Good afternoon, everyone, and thank you for joining us this afternoon. It's that time where we get to the fourth part of the data privacy webinar. It's been quite a long series. We have since the data commissioner has started actioning on doing audits for some firms. So it's time we all think of being compliant. Today, our presenters will focus on the data protection laws in East Africa. We'll have Zahir Sheikh, our partner in forensic and internal audit, and Amit Gadia doing the presentation. We're hoping to release you within an hour's time. Please note that this webinar is recorded and it's on live on YouTube, so it will be published on YouTube. That is for your information. You can submit your questions in the Q&A section and all the chats, your comments can be placed on the chat section. We will address your questions much later after the presentations, and those that we will not manage to address today will be responded to via email. We have concerns about the certificates for the previous webinars. Our apologies. We have a few issues with the system that generates certificates, but we will be sure to send them more. We have your records, so we'll send them. As for the presentation, unfortunately, we are not in a position to share that content, but everything that's presented will always be available on our Video in East Africa YouTube channel. We'll now invite Zahir to take over.
Thanks, Virginia, and good afternoon, good morning, good afternoon, good morning, and good evening to all of you. It's my pleasure to be back with yourselves on quite an important topic. Today, we're actually getting to the nitty-gritty of, what the data privacy laws are all about, and how we can actually apply them. So yeah, it should be a very exciting and interesting episode today. Myself, Zahir, and Amit here with you. We've not got our lovely co-presenter from Mauritius today, but I think she will be back for the final presentation. So I think you all do know me. I am partner for risk advisory, internal audit, and forensic services. I'll give you a little bit of background about BDO. BDO is the 5th largest advisory firm in the world. In 2021, we had a turnover of nearly $12 billion US. We have offices in 164 countries. We have 1,713 offices and nearly 100,000 professionals working for us. We provide services in audit, in tax, in business support and outsourcing, and also advisory services. And we provide a full range of advisory services. You can see we have a fairly large footprint in Africa from all those countries in the blue, and the East African Partnership specifically covers Kenya, Uganda, Tanzania, Rwanda, and Ethiopia. Like I said, we provide a full range of services, audit, tax, business assurance, business services and outsourcing, as well as advisory services. And within advisory services, we do internal audit and risk management. We do consulting. We provide insolvency and business turnaround services. BDO has been #1 in terms of deals worldwide for a number of years now. We do the highest number of deals in corporate finance and transaction services, whether it's mergers, acquisitions, takeover, partnerships, and so on and so forth. And we also provide a range of technology advisory services. We started off our webinars with part 1, which was registration with the Data Protection Authority. In part 2, we covered the key roles for the data controller and the data processor. Last month, we spoke about your compliance journey and how we can assist. And today we're going to talk about the detail of the data protection laws in East Africa. And we're going to give you a couple of examples of, things that have gone wrong in terms of data breaches and some of the consequences, across the world for those, who've fallen foul of the law. And in the final part, we're going to give you some tips on how to avoid complaints from the law, the regulatory bodies. Today's agenda, we're going to talk about personal liability for directors, and we'll give some examples of recent cases. We'll talk about the Uber case, which is very recent and unfortunately may set a wrong precedent, but we'll talk a little bit about that. We'll also talk about recent action taken by the Office of the Data Protection Commissioner in Kenya. And then we'll look at some of the administrative and criminal sanctions. We'll then go through the laws in East Africa, some of the common themes and the differences, and also the guidance from supervisory authorities. And finally, we'll take some questions and some answers. So, personal liability for directors, recent cases. In recent months, a trend has begun to emerge amongst plaintiffs' lawyers. These are lawyers who are acting for either a shareholder or a group of shareholders on behalf of a company seeking to file cybersecurity incident-related shareholder derivative lawsuits. Now, these derivative lawsuits are the ones that we're saying are brought by shareholders amongst and on behalf of the company against the directors of the company and the office holders of the company. So quite interesting. And a lot of this is actually gaining momentum. Attorneys are now increasingly filing claims specifically based on failures surrounding the director's duty of oversight. So in November of 2021, a shareholder derivative lawsuit was filed against T-Mobile, US's board of directors. And the lawsuit pointed to a lack of monitoring and failure to act upon obvious red flags. A gentleman who specializes on these sort of lawsuits, he's recently outlined, Kevin Lacroix, he's recently outlined this trend in the director and officer's diary, the DNO diary. So directors, please take notice. We all know that directors have a fiduciary duty to the company's shareholders. That is, they are entrusted with the affairs of the company on behalf of the shareholders. And in that capacity, the directors are mandated not only to address cybersecurity threats and remediation, but to consistently and regularly monitor cybersecurity practices and to correctly relay that information to all of the stakeholders. So in the above mentioned T-Mobile case, this involves whether effective internal controls were in place, while it also questioned whether the directors abetted each other, they helped each other in breaching their fiduciary duties. These allegations are quite serious for directors with potentially serious consequences for both the company as well as the individual directors. It's not clear that all directors possess, it's clear actually that all directors don't possess adequate knowledge, and some of them don't even have the basic elementary knowledge of information technology, let alone things like cybersecurity and proper precautions and defenses against cyber attacks. However, a board of directors is obligated to either possess or to find that talent from third parties and include them in its ongoing governance. In turn, boards can then make proper decisions and communicate the necessary relevant information to employees and stakeholders. It is the responsibility of every board member to ensure that the board is fully engaged in cybersecurity practices and also in more detail. For example, it's aware of the fact that tests are being conducted, improvements are being made along the way, directors no longer get away with this excuse that they are not subject matter experts. And many directors have, unfortunately, come to realize this the hard way. A global survey conducted last year among directors and officers indicates that they themselves consider cyber attacks and data loss to be among the top risks that their organizations face. So whether a director's focus is on a compensation committee or some other non-IT role, they must still realize that cybersecurity is not simply an IT issue. Data breaches and ransomware attacks obviously have the potential, and they can have devastating effects, which result in huge losses in so many other ways as well, from revenue to reputation and much, much more. But as we can see now, lawsuits, from the recent lawsuits, personal liability for directors is taking up a dramatic and new place on the horizon. So whether internal or external stakeholders, no one wants to experience the ramifications of a cyber attack. You know, this obviously has an impact on everyone. And these recent lawsuits seem to be an indicator that individual board members can and should become a helpful and powerful force towards minimizing cyber risk, which is why there continues to be more and more emphasis on their responsibility or alleged responsibility when a cyber incident takes place. So at least initially, there are some basic questions that every board should ask. Does the board currently review the organization's preparedness to respond to a data breach? In particular, how prepared for a data breach is the organization, and that preparedness, is it sufficient to reduce the cost of a data breach when it happens? So are they prepared in terms of response? And if so, does this preparation include things like a cross-functional incident response team? Is there an incident response plan? And has this been tested by the team? And do they have a plan? One of the other questions is, does the board currently ask the organization's most knowledgeable employees to review and answer its cyber security related questions? And finally, does the board ask those same individuals to appear before it and explain each answer with enough detail so that members can make an informed decision on appropriate actions? I mean, these initial questions, they provide some guidance and they begin to start some conversation towards ensuring that organizations are resilient. And also, I mean, in terms of reducing the liability amongst directors. I also want us to look at the recent case of Uber. So former security chief was found guilty, this gentleman, Joe Sullivan, of hiding attack from authorities. A jury of 12 people, 6 men and 6 women, recently, as recent as 5th of October, in fact, this was in the New York Times, so it's one of the most recent rulings, found Joe Sullivan. He led the security at the ride-hailing company, and he was found guilty on 2 different counts. The case has the potential to change how security professionals handle data breaches. Now, what happened is in 2016, while the FTC, the Federal Trade Commission, was investigating Uber over an earlier breach of its online systems, so there was already an investigation going on. And then this, I think it started in 2014. And in 2016, Mr. Sullivan learned of a new breach that affected the Uber accounts of more than 57 million riders and drivers. The jury found Mr. Sullivan guilty on one account of obstructing the FTC's investigation and one account of misprision or acting to conceal a felony. In the US, a felony is basically a serious crime, and it's more serious than a misdemeanor. So basically, he was accused of misprision from the basically concealing the data breach from authorities. The case, this is believed to be the first time that a company executive and not the directors faced a criminal prosecution over a data hack. And this is likely to change how security professionals handle data in businesses. One of the scholars at the Robert Strauss Center was quoted to say, he's basically a lecturer at the University of Texas in law. And he was quoted to say, the way responsibilities are divided up is going to be impacted by this. What's documented is going to be impacted by this. The way bug bounty programs, bug bounties are basically programs in the US for payment of ransomware demands. So the way bug bounty programs are designed is going to be impacted by this. This case has caught the headlines all over the world. The conviction hasn't sent tremors through boardrooms across America, but it's definitely sent chills up the spines of CISOs and CSOs, I mean, Chief Security Officers and Chief Information Security Officers. This is the first time that a CISO or CSO has been held criminally liable for their actions in managing a cyber attack. And until companies treat cyber as an enterprise risk and make business units responsible for the systems and data they use, cybersecurity programs will continue to lag, and security officers will be incentivized now, especially, to minimize or to even lie about cyber attacks. And that is definitely a scary thought for the corporate world, because our current state of cybersecurity, it plays a key role in national as well as economic security. So imagine, if just one officer was pinned on this, and for sure, spreading responsibility for cyber risks across an organization and onto the board of directors and the CEO is definitely best practice. And it's the only way that cybersecurity programs are going to get implemented in operations, and they will get the attention that they deserve. We've also had some developments in our local market. This, what you're seeing the slide here, is a notice. It's a press release notice against by the ODPC in Kenya against 40 digital lenders who are now going to be audited, and also one of the health service providers. And basically, it's amounted from claims that they received, for data breaches, basically. So they have a service where people can file complaints, and they've had several thousand complaints already. And what they do is they vet these complaints, and then the ones that merit, they deserve merit, they basically begin to investigate. So you can see that our own authorities are also taking serious action here. Just very quickly, I'm going to look at the Kenyan law, and obviously Amit is going to go and look at all of the laws across East Africa. But just in terms of the data sanctions in the Kenyan law, first of all, there's administrative sanctions. The DPA gives the Office of the Data Commissioner the power to impose administrative fines for failure to comply with the DPA. And there's a fine of up to 5 million shillings or 1% of annual turnover, whichever is the lower. And this fine is payable to the Office of the Data Commissioner. And then failure to comply with an order. So if, say, for example, the Data Commissioner has written to these people now, asking for them to comply, asking for them to provide certain information, that's an order. Failure to now comply with an order is considered an offense under the DPA, and under Section 65 of the DPA, this accords all data subjects with the right to compensation from data processors and data controllers for any damage caused to them. So those are the administrative sanctions. And then you've got a whole host of criminal sanctions. So there's the unlawful disclosure of personal data in a manner incompatible with the purpose for which the data was collected. There's the unlawful disclosure of personal data that the data processor processed without prior authorization of the data controller. There's obtaining access to personal data without the prior authorization of the data controller or processor who holds the data. There's the disclosure of personal data to a third party without prior authorization by the data controller or processor holding the data. And there's also the sale of personal data, which is obtained unlawfully. And in fact, advertising the sale of such data constitutes an offer to sell and is an offense. And then there's failure to register with the Office of the Data Commissioner as a data processor and data controller. We touched about this as well. And then obviously a more serious one is the obstruction of the Office of Data Commissioner during an investigation. And this is what we've seen in the case that we just mentioned. This was the allegation in the case that we just mentioned just now. So on conviction, basically the fine, you've got a fine not exceeding 3 million or imprisonment 10 years or both. And for obstruction of the data commissioner during an investigation in any manner, there's a fine not exceeding 5 million or imprisonment for a term not exceeding 2 years or both. Now, at that very grim note, or on that very grim note, I'm going to hand over to my colleague here, Amit, to take you through the rest of the presentation for today. Amit.
Thank you, Zahir. Hello, everyone. My name is Amit Gadia. Thank you, Zahir, and the video team for introducing myself. What I'm going to be doing today, I will be specifically taking you through the key areas of data protection laws across East Africa. And this is going to include Kenya, Uganda, Rwanda, Tanzania, Burundi, DRC, and South Sudan, which comprises of the East Africa community. Before looking at East Africa, it is important to look at what the African landscape is like in terms of privacy. I am very happy and very proud to say that this year, Africa is the global continent of privacy. Over 65% of the countries in the continent have a data protection law, a specific data protection law. We also have an African Union Cybersecurity and Personal Data Protection 2014, which is known as the Malabo Convention, which is yet to come into force because less than 15 member countries in Africa have ratified the convention. In East Africa, currently only Rwanda has ratified that convention. Most African laws currently are based on the General Data Protection Regulations, which is the GDPR as commonly known. And this is the data protection law, which is first took root in Europe. The GDPR is the global template for most data protection laws with many minor and major differences, which I will go through in this webinar. And we also have now the UK GDPR, which currently mirrors the current European GDPR, but there is a bill in the UK Parliament for the UK to have its own bespoke data protection laws. Coming back home, in Kenya, you have the Data Protection Act 2019, the regulations, which are the General Regulations 2021, and the Registration of Data Controllers and Data Processors 2021, and the Complaints Regulations. The Act came into force in November 2019, and the regulations came into force in July 2022 this year. They were gazetted in January 2022. And in Uganda, you have the Data Protection Act 2019, the Data Protection Privacy Regulations 2021, and in Rwanda, you have the Protection of Personal Data and Privacy Laws. In Rwanda, there is a transitional period under Article 2067 of their Act for a period of 2 years from 15th October 2023, which means it's going to have force from 14th of October 2023. Next slide, please. Now, coming to some commonalities, I will, first of all, before going to the next slide, sorry, Zari, if you can just take me back a little bit. I will not do any justice if I do not mention our neighbors. Tanzania has a draft data protection bill, which is introduced just less than a month back in its parliament, which it is very much similar to our the three data protection laws across the three countries, Kenya, Uganda, and Tanzania. Kenya, Uganda, and Rwanda. Burundi currently has no specific data protection law. The DRC neither has any data protection laws. And South Sudan, there is a draft data protection bill, but we are not sure when it is likely to be presented in Parliament. So for purposes of this webinar, we will be focusing mainly on the three countries when we make the comparisons and some common themes. Next slide, please. So let's start with data subject rights. So we'll be covering the data subject rights, the principles of data protection, and the lawful basis of the data protection across the three countries. Now, these three areas are the foundation principles and are the foundations for any data protection laws globally, and which requires demonstration by organizations or data controllers, if I may use a technical term, for purposes of demonstrating compliance across your organizations to be compliant with the acts. So starting with right of access, all three countries have the right to access. So briefly, right to access is individuals have the right to access and receive a copy of their personal data and other supplementary information. This is commonly referred to in the GDPR as well as our data protection acts as subject access requests. There is also the right to restrict, where individuals have the right to request the restriction or the suppression of their personal data. Although this is not an absolute right, it is only applies in certain circumstances. We have covered data subject rights, or we will be covering in future webinars. And so I don't want to go into too much detail on it at the moment, but needless to state that when processing is restricted, you are permitted to store the data, but not to use it for a certain period of time. Then there is the right to object. The right to object gives individuals the right to object to processing of their data in certain circumstances, and they have an absolute right to stop marketing their data being used for direct marketing. This is very important to know, because if you are going to be doing direct marketing across your organizations, you do need consent, or if you are going to be using personal data for purposes of doing direct marketing, you will need to have consent. And this applies to current data, future data, as well as past data. In other cases where right to object applies, you may be able to continue processing if you can show that you have a compelling reason for doing so. Then we move on to the right to correct. So the right to correct is, for example, if your data is in any way or form not correct, or it is inaccurate, you have the right to have their personal data rectified or completed if it is incomplete. So for example, if you are, your previous name is in your maiden name, and you get married, you decide to change your name, or you decide to merge both your second names together, then you can, it is your right to go to whoever is processing your personal data and tell them, I want my maiden name to be included as well. And then you have the right to delete. This right to delete is known as right to be forgotten, or the right to erasure. And then there is a right to, this is basically a right of individuals to have the personal data erased. Sometimes the right to erasure is also known as the right to be forgotten, as I said. Again, it is not an absolute right. It only applies in certain circumstances. We'll not go into those depths at the moment. The right to portability, it is under the Kenya and Rwanda Data Protection Act. However, it's not that in the Uganda Data Protection Act. The right to portability is again very, very specific. It only applies where individuals have the right to obtain and reuse their personal data across, for their own purposes, across different services. And it allows them to move, copy or transfer personal data easily from one IT environment to another in a safe and a secure way without affecting its usability, and it has to be in a usable format. So to give you an example is, for example, if you move from one telecommunication company to another telecommunication company, you have a right to port that data. Having said that, this right is very seldom, hardly ever used, and we don't know how it is going to come into force in future. And it remains to be seen even in some of the most advanced data protection regimes like Europe. Next slide, please. Now we are moving on to the principles of data protection. In any jurisdiction, whether it is in Europe, Kenya, Uganda, Rwanda, you are going to be seeing that the principles of data protection are going to be paramount, and you are going to be asked to demonstrate that how are you adhering to the principles of data protection. So you must have seen the notice from the ODPC in the beginning, which Zahir looked at and he showed us, and one of those sections did refer to, can you please show us how are you demonstrating the principles of data protection. So I will briefly take you to the each of these principles. The notice and transparency. Transparency is fundamentally linked to fairness and notice. This is a global, universally accepted principle of data protection in any jurisdiction, right? Whether you are in the Far East, Middle East, in East Africa, or in Europe, okay? So transparent processing is about being clear and honest with people from the start, how about who you are, how you are using that data, and why you're using that data. And then you need to notify them of their personal data, how you're processing the personal data, who you are sharing it with, the lawful basis for processing, how you are going to retain it for. And this is normally in all your organization's privacy notices or privacy policies. We have a purpose limitation. So the purpose is, from the onset, you must be clear about what you are going to be doing with that data from the onset. So for example, if you are taking data for purposes of, say, somebody's contract or entering into a contract, you need to also inform them if you are going to be using that data for marketing, or if you are going to be using that data for any form of research, right? You cannot say you are going to be doing it for entering into contract with them and then proceed to send the marketing emails. No, that's not right. That's the purpose limitation. Data minimization, we have all seen forms where you take humongous amounts of data, which probably a lot of it is irrelevant. I commonly give this example is when a candidate is applying to organizations for employment, you need to ask yourself that at this stage, when a candidate is applying where they're not really successful and they are going to go through hoops of interviews or stages, do you need to really take their next of kin? Do you need to really take their, say for example, their ID copies? Or are you just trying to filter down and say this candidate is right or is not right? So data minimization specifically states that you must ensure the personal data processing is adequate, sufficient to properly fulfill your stated purpose, relevant, and only limited to what is necessary. Okay, moving on to accuracy. You should take all reasonable steps to ensure that the personal data you hold is not inaccurate or misleading to any matter of fact. Accuracy becomes very, very relevant in that tomorrow what happens is, for example, if you go to a telecommunication company and say, look, my mobile phone is not working well, they'll ask you to identify yourself. If you are going to a bank or a financial institution and you need your bank statement, and if you're telephone banking, internet banking, I think majority of us go do internet banking, you'll be asked to identify yourself, okay? So it is very important that whether you are a bank or an audit firm or an insurance company, you need to make sure that you take data accurately, because the cost of acquiring inaccurate data can be very costly, because you need to even pass on that processes to your processors eventually. Retention, limitation. So the limitation purpose across all 3 countries specifically states that you cannot keep personal data longer than you need it. So essentially, I have seen some, if I can call that horrendous or ludicrous, where some organizations actually hire warehouses for purposes of storing personal data, which dates back to decades. This is not allowed, right? You cannot store data forever. You have to come up with a specific period of time, 6 months, 1 year, 7 years, 10 years, depending on the circumstances of how long you're going to keep that data for. You then also need to justify how, with specific purposes of, if you have a particular law or a court decision or your experts advise that, yes, you can keep this data for so long. It all depends on your specific purposes for holding data. Finally, lastly, but most importantly, data protection is about putting safeguards across all 3 continents. You must ensure that you have appropriate security measures in place to protect the data you hold. Okay, next slide, please. Lawful basis for processing personal data. I cannot understate how important it is to process personal data with a lawful basis. If the simple statement is, if you do not have a lawful basis, you cannot process that data. Okay, and you are confined within the confines of these 6 to 7 lawful basis for processing personal data. Let me start first with children's data. This children's data, which is at the bottom of this slide, I wish I would have kept at the top. It cannot be understated. You will find that in the next coming years, children's data are going to be the highest find probably globally. Children's data, even the President of the United States has actually stated that children's data is paramount to be secured. Now, I'll give you a few examples. A month back, Ireland Data Protection Commission, DPC, they decided to levy a fine of 405 million euros on Meta. Meta is a parent company of Instagram, Facebook, we use it. This is the second highest fine globally for data breach. And that was basically for not notifying the children who are using Instagram under the age of 13, that when they change their accounts from personal account to business accounts, all their data will become transparent to the entire world. So their names and email addresses, right? This is the second highest fine globally for data breach. The first one was Amazon, which was last year of 880 odd million euros, which is equivalent to GDP of some of the countries in East Africa. TikTok is currently facing 27 million pound or $29 million fine after UK Information Commissioner's Office provisionally found that the company breached children's data protection laws for two-year period. Okay, there is a for those of you who have access to the BBC or BBC iPlayer, there is a documentary which I would strongly recommend you to read it as to how TikTok is now, or you can read it in the news as well, how TikTok is actually in Ukraine. Children are being lured into exchanging tokens via TikTok into real money, and how this is a documentary. It is live. It is in the news. How TikTok is now then takes 70% of those tokens, right, and then uses that instead of passing it to those children. It is a quite sad state of affairs. So those of you, whether knowingly or unknowingly, are using children's data, you're using them for purposes of mentoring or training or some form of whatever you are doing with it, right? Events. Make sure you secure it because it is going to become paramount. Going to the other lawful basis, you have the lawful basis of consent. Consent is basically all our data protection laws, GDPR, as well as our 3 countries, they set a very high standard of consent. You will often not need consent. Now that data protection acts in the 3 countries are taking, they're raising their head quite high and keep coming very hard and fast. I am seeing organizations run around with consent forms and asking everybody to sign consent. No, that is not the right way of doing things. Consent, it's often difficult. Consent is normally very difficult. I mean, it depends on case-to-case basis. You often will not need consent, but even where you do take consent is you need to give individuals a real choice and control. Consent across the 3 countries requires a positive opt-in. So you cannot tomorrow tell your employees that you need to consent to this, failing which you will not be able to continue with your employment. You cannot tell your customer that you need to consent to give us your marketing data, failing which you cannot purchase or continue the purchase online. And the other thing is the consent needs to be freely given, voluntary, and in the language the data subject understands and individual understands. Now, you can imagine the amount of languages and dialects which are spoken all across East Africa. It is going to become a nightmare, right, in years to come. So you need to look for other means of looking at the lawful basis for processing. Contract is fairly simple. You need to have this lawful basis for purposes of entering into a contract, whether you're a processor or a contractual service you're delivering to them. And then legal obligation, you can rely on this lawful basis if you need to process data to rely on a common law or statutory obligation. This does not apply to contractual obligation. So I often get asked questions that, we are entering into the contract, so it is our legal obligation to process this data. I said, no, your lawful basis will be contract, is not legal obligation, because legal obligation need to have what you call an appropriate document, a common law or a statutory obligation for that. Vital interest is basically mainly to protect someone's life. So it only applies mainly in life or death situations. Legitimate interest, I get asked this question quite a bit, is like, can we rely on legitimate interest as a lawful basis? I said yes, but only if you can prove that it is not a risk to the rights and freedoms of an individual. If it is, you cannot. Okay. Then public interest, public authority mainly applies to public organizations, or if you are acting in your official capacity, though you may not be a public organization. So if you are doing anything as an official capacity. Statistical research purposes, you can do you can process the data and use that basis. For purposes of historical processing, which is used for historical or statistical purposes, and so long as the person ensures the further process is carried out solely for the purposes for the data in which it was collected. Okay. Next slide, please. There are some very notable differences between among the 3 countries. And I would specifically come to sensitive or special category data. So as you can see, I have taken the definitions from the 3 countries. So in Kenya, it's a person's sensitive personal data is a person's race, health, self-status, ethnic social origin, conscious belief, genetic data, biometric data, details, marital status, family details, including names of children, parents, spouses, sex, or sexual orientation of the data subject. Uganda, you have the philosophical beliefs, political opinions, sex life, financial information, health status, or medical records. Rwanda, you have the person's health status, criminal records, again, medical records, social origin, religious or religious belief, political opinions, genetic or biometric information, sexual life or family details. I also need to state that sometimes I have found that when processing personal data, a lot of organizations I've come across, they are asking for consent to process sensitive personal data. Again, that is not very correct. When you're processing sensitive personal data, In order to process, you must have the lawful basis for processing sensitive personal data, which was in the previous slides, and a separate condition for processing under the respective regulations. They do not have to be linked, and it does not have to be the consent. So when you go into details of these regulations, you will find there are specific consents, sorry, my apologies, the specific conditions on which you can process sensitive personal data. So you need to look at that as well. Okay. Going on to privacy by design. So privacy by design, and essentially it is, you need, whenever you're building an application or a website or any form of software or any technology, you need to have privacy built in from onset, not as an afterthought. And the privacy by design is specifically, provisions are in the Kenya Data Protection Act, although I've not come across them in the Uganda or the Rwanda data protection laws specifically, although they may have been encouched in different terms. But then privacy by design, you will find in years to come, it is going to become very, very important, especially as technology advances. And you have all new forms of technologies coming in. Next slide, please. There are minor but very important differences among the three countries when it comes to data, the Data Protection Act. Again, data controllers definition is universal across the three countries. It's very standard. So you're a data controller if you're a decision maker when it comes to how you are using people's data, information, how it's handled, how you keep it safe. You're a processor only if you're acting on behalf of the instructions of the controller. Normally it needs to be in writing. Okay. The difference between the controller and a processor, and you might ask, why is it important? Because sometimes someone ultimately needs to be responsible to make sure how the personal data is handled lawfully, fairly, and transparently, and that people are protected from the harm and their information rights are upheld. And Uganda introduces the definition of a data collector, right, which is not in Kenya or under Rwanda data protection laws. So it means a person who collects personal data. So it is a new term which has not been, it's not seen in the GDPR either. So it remains to be seen how it's likely to be interpreted in future because our laws are fairly new. But I would think that there is a lot of similarity between a data collector and a data processor. So even if you, for example, just collect the data, you don't have any instructions from the controller or a processor, and then whatever you do after your collection, you are still responsible to abide by the Uganda data protection laws. Okay. There are areas where I think there are some very good provisions in the Rwanda Data Protection Act. For example, personal data of a convict. So once you're convicted, you have actually paid your time to the society, and you have been in prison. Yeah, you need to be given the time to reform, to rehabilitate. Okay, and so in accordance with the Rwanda Data Protection Act, is personal data of a convict is carried out under the supervision of the supervisory authority in accordance with the provisions of the Rwanda Data Protection Act. And the data controller, the processor, must put appropriate safeguards in place to ensure that to respect the rights and freedoms of that convict. So once you're a convict, you've served your time in prison, or however you've been sentenced, you need that your data to be processed in a way which does not prejudice you for your entire life. Okay. The right to designate an heir to personal data. Now, this is also very important. I always keep on asking that if you have your Facebook account or your whichever social media account, what happens to it when you die, right? Because you can't access it. Your heirs cannot access it. Your children cannot access it. How do you delete it? And it is sometimes very offensive to the person who has passed away to have their Facebook account there forever, knowing that he's not there, or the social media account there forever. So under the Rwanda Data Protection Act, you have a right to designate an heir to personal data. So this is the personal data, it specifically says the personal data of a data subject is not subject to succession. However, a data subject has left a will and the data provides in his or her real will with full or restricted rights relating to the processing of personal data to be kept by the data processor, then you can have an heir to your personal data. A right to representation. It's again in the Rwanda Data Protection Act. We don't have it in our the Kenya, the Uganda one. Is the right to represent access. You can represent someone where the data subject is under the age of 16, or there's some physical impairment, or they're unable to represent themselves, so they can represent themselves, or they're medically there's some form of mental impairment, right? So that is the right to representation. Next slide, please. All three countries have got some fantastic resources on their websites, right? So in as much as they are enforcement authorities, they also give you guidance and opinions as to what should be done and what should not be done, right? So in Kenya, we have the updates by the Office of the Data Protection Commissioner. So currently they've got guidance notes on instructions in the DPIA, the form of the DPIA template. They've also got guidance notes on consent, on registration of data controllers and processors. Next slide, please. Uganda, we have the obligations of the data controllers by the Data Protection and Data Privacy Act. They've also got the Data Protection Search Register. By the way, just these slides are probably just more than 2 days old. Our Kenya Data Protection Commissioner has now also got a search register. So if you go to Data Commissioner's office, you can see who has actually registered in the Data Protection Act. And the Uganda Data Protection Act, the Personal Data Protection Office has also got Data Protection Search Register. So you can go in, you can type any organization, and you can see whether they register or not. And they've got our FAQ hub as well. Next slide, please. The Rwanda National Cybersecurity Authority is the one who is responsible for giving updates. And though there is a moratorium period, you can still go in and see exactly. They've given a lot of guidance. So how to prevent data breach, what are your rights to object, what data subjects need to know about privacy policies, and so forth. Next slide, please. Finally, the Tanzania data protection laws is already there. You can go through it. It is currently only available in Kiswahili language. I've not come across the English version. And it was tabled in the parliament less than a month back. And we hope this time next year when we speak that it should be into law. And yeah, that brings me to an end. Over to you, Zahid.
Thanks, Amit. And thanks for that fantastic summary of the laws and the comparative laws in our East African countries. That brings us to the end of today's session. Ladies and gentlemen, very quickly, if you do have any issues and if you need assistance, BDO is there to assist you. These are some of the services we provide. We can do a gaps assessment. We provide data protection, remediation, and implementation, including drafting and implementation of policies, procedures, as well as contract clauses. We can do complete data protection audits. We also provide a outsourced DPO service, and we've got various trainings on DPO, data inventory, staff awareness, DPIA, as well as privacy tools. That then brings us to the end of today's session. If you do want to contact us, there are details, my own detail, as well as details. I basically represent the 5 countries, Kenya, Uganda, Tanzania, Rwanda, and Ethiopia. And if we've got people from Mauritius, then basically there's a contact, a phone number, and an email address there as well. You can make note of those. If you have any inquiries, we recently received an inquiry for data privacy laws in India, and we're dealing with that as well. So we can take inquiries, your inquiries on data privacy for any country. You can just basically pass them through myself, and I will then channel them to, I will put you in touch with people that will be able to provide assistance to you. So thank you very much. And we have got a couple of minutes for questions. So I'll hand over to you, Virginia.
Thank you, Amit and Zahir, for that presentation. Thank you for taking us through the different, showing us the few differences we have in different countries. We'll now go to the Q&A questions. There's a question from Josephat Zomo. Kindly, if you have any questions, post them on our Q&A section. Right into it, can an organization register as both processor and controller? I believe Amit can address that one.
Amit, you there? I'll take that. Yes, an organization can register.
Sorry, my apologies.
As a data controller and as a data processor. Those two are separate roles, and the Act does provide for registration both as a data processor, if you're processing data, and also as a data controller.
Thank you, Zahir. Sorry, Amit, we had lost you for a minute. We're going to close the webinar at this point, but don't forget to join us for the very last episode on the 23rd of November, where we'll take you through the tips to avoid complaints to the regulatory bodies. I believe we've already seen the people who are already in trouble. So that's the webinar is meant to help you avoid that list of shame. So join us on 23rd of November. We'll send an invite to the people who have given us consent, but you can view all our invites and registration links on our social media channels and our website. Thank you, and see you in November. Bye.
Bye, folks.